SJC-13406, Cummings Properties, LLC v. Darryl C. Hines.
Okay, Attorney Simons.
Good morning, Chief Judge and Justices of the Court. The primary question in this case is whether or not a commercial landlord can enforce a liquidated damages clause against a tenant who's breached the contract in full that would account for a full accounting of the remainder of the lease and at the same time collect by reletting the premises to a new tenant. In this case,
So I just curious, I get that it doesn't seem fair, but how do you get around the fact that that's the contract? That's what your client signed.
well, because contracts are not always enforceable, and specifically the case law that involves liquidated damages requires a couple of things. One is that the damages are difficult to ascertain at the outset, and that they're a reasonable estimate of the potential damages that are likely to be in this case.
How do you get around our case law?
I'm sorry, in what?
National, right? The national case?
The Cummings property case.
Yeah, the one where, with Cummings in it, yeah, the same facts. Yeah, exactly.
Well, in the Cummings case, which predates the NPS, which I guess are the two kind of big cases I would suggest in this area, the Cummings case specifically, the court said we need not decide whether the failure to mitigate damages might ever affect the enforceability of a liquidated damages provision, as National did not plead below, National being the defendant. Here, Darryl Hines, being the defendant, did in fact plead that and made the case in the trial court and the appeals court that there was just not a live issue in the prior case. So it's not asking this court to make a different decision. This is a different set of circumstances and different pleadings that the parties are asking, that Mr. Hines is asking.
Wasn't it in the footnote that they knew that he relet? Wasn't there in a footnote that said, in that case, they actually relet?
There was a footnote, but I would still suggest that that case doesn't create the precedent that holds the proposition that a landlord can relet and seek the entirety of the damages. To the extent that that is this court's interpretation of that, I would urge the court to adopt a different standard, because it clearly, if you look at the facts of this case, it clearly should go against public policy for a landlord to take the position, as Cummings does in this case, that Mr. Hines could sign on the dotted line on a contract, the next day or even the next minute could say, never mind, I can't do this. Because of the facts of this case, Mr. Hines had testified at trial that he alerted Cummings less than a month after he signed the dotted line and before he took possession that he was in a different financial position.
The question is whether a sophisticated tenant in the commercial context with the ability to negotiate can agree if the landlord doesn't want to take the chance of having a shuttered tenant building with all the implications that go along with that and all the costs that are not easy to be able to quantify. Maybe it's a restaurant. Maybe the restaurant is a magnet that brings in other folks or is great for other employees of other businesses. And if that's what they want to negotiate, because that might actually correlate with real damages, let them go to it.
Well, I think that could be an argument for the liquidated damages, but I would suggest not for the also reletting and getting the same rent that you would get from a new lessor. I think that the lessor has to, or lessee rather, the lessor I think has to take one of the other options for it to even be enforceable.
But there's no mitigation in that context.
Well, maybe I could address one of the things that Your Honor said about the sophisticated parties. That's something that Mr. Hines had pled in the trial court and the appeals court, although the appeals court decided they didn't have to make a determination as to whether he was a sophisticated party or not. I think that this court should rule that he was not a sophisticated party, and there's very little guidance on that fact. There's some case law that references that a liquidated damages clause with sophisticated parties should be upheld, given the other.
We'd have to find the judge clearly erroneous on that, right?
I would suggest not, though, because the facts aren't really in dispute. And I'm not asking you to change a factual finding by the trial court. I would argue that it's a question of law as to whether somebody.
You're saying a question of law as to whether somebody is sophisticated? That's a legal question?
That's what that's what Mr. Hines would argue, that it's a legal question as to whether somebody's a sophisticated party.
You look surprised, but I bet you he's got an explanation.
Well, I think that in a case like this where there's really no precedent, I think, first of all, I'd be asking this court to create some sort of guidelines as to what trial courts can consider in terms of what a sophisticated party is. And in this case, the trial court judge just didn't have that ability. And so if this court does not decide that whether as a matter of law Mr. Hines was a sophisticated party, there will be no guidance for
But you're
future.
saying there's no standard to apply facts to.
Exactly. There's no standard to apply facts to.
Before you run away from the hard part, though, because we took the case on the first issue primarily. So do you want to tell us how you could, I mean, like I read Reba's brief, which is basically we want compensatory damages to be the standard, but how do you know up front? I mean, it's supposed to be easy to quantify, and what they're proposing seems very difficult to do, to estimate and ascertain it. It's basically an after-the-fact inquiry. Isn't liquidated damages the opposite? We want something easy to quantify, and we can do it up front. It may be rough, but it's not taking into account all the contingencies that come with compensatory damages, mitigation, whether you got someone in, whether you had to clean up their mess, any of that, right? I just don't know how we do that.
Well, first of all, I agree that the case law is not to take a second look after the fact. It's at the time of the contract, whether there's the ability to forecast the damages and whether there's a reasonable estimate contained in the liquidated damages clause. And I would suggest that there is a way to calculate or in the abstract.
How tell me, because again, it's supposed to be something that we're done up front.
Sure.
And the appeals court kind of basically says you got to do compensatory damages, and I just don't know how that's liquidated damages. It just seems like it's the opposite.
Well, given Cummings Properties' size and their operations that were available at trial, that I would suggest not just after the breach and after the subsequent mitigation, but the evidence I suggest would infer that they had the ability beforehand. I mean, they had a number of executives, the size, the scope of the operation. They clearly could have made a reasonable forecast by what is their historic rental, ability to relet a
Yeah, so that
place.
might have been a more reasonable approach, but why is this approach unreasonable?
Because it contemplates the absolute best case scenario for the landlord. There's no sign that there was any sort of negotiation or even contemplation of what a reasonable standard. I mean, if the reasonable standard is always going to be the most favorable for the landlord, meaning the total rent that's due under the lease,
Isn't that what they bargained for? I mean, isn't that what they're at least supposed to get? I mean, I think Justice Lowy gave an example of perhaps getting more than the rent based on what's around them and whether the company attracts other businesses. But they should be able to expect the full amount of the rent.
I would suggest that it would require the parties to do something to forecast the reasonable amount of damages.
But yeah, so the reasonable forecast was, let's say it's, $200 a month, and it's a 24-month lease. My most reasonable estimate is $2,400, 24 times 200. Why is that unreasonable?
Because that would assume that that a landlord is never going to be able to relet the place, that they're just going to be.
Well, everything's going to have some assumptions. I mean, your, economic model of using Cummins' expertise based on past history to predict what will happen in the future and how easy it will be to rent in Woburn also has certain assumptions.
Of course, there's always going to be some guesswork involved, but I would suggest that.
Right, so given that there's always going to be some guesswork, why not do the simple math? I want to get $200,000 over 2 years, and I'm going to let you pay it monthly. but at the end of the day, I want to have $200,000.
I would suggest that it is so profoundly unfair that public policy can't let it occur because, yes, the 24 months doesn't sound terrible, but what if we're at one of the panel of the appeals courts, suggested, what if this is a 20-year lease and somebody defaults on the first month or on the first day? Is that still going to be a reasonable forecast of damages? I would suggest it can't be. And if the court holds that a reasonable
A sophisticated, again, that gets to the sophistication, because, again, if we're not saying we're going to impose this on, someone who's not sophisticated, but again, in your example, you enter into a 20-year lease. One, you're going to be somebody who can, we assume, afford it, but maybe not. But the sophistication allows you to renegotiate the liquidated damages provision. Your client says, okay, you want to liquidated damages, I think that's fair, but how long does it take you to relet? I'll enter into a liquidated damages based on that percentage of time, just what you talked about. But your client didn't do that. And they say, hey, I gave the lease to you rather than someone else. I might have picked somebody different who could pay.
And just lost out on 20 years, so there should really be liquidated damages. That's the argument for more among sophisticated people contracting, not less.
Right. Or you just don't have to go to Cummings.
I'm sorry?
Or you just don't have to go to Cummings Properties, one of their properties. Or you just don't have to go there. You can find somebody else with more favorable provisions or somebody that's more willing to renegotiate that provision. Can you help me? Can you help us out with that?
That's true, of course. You could go to a different place that offers rental property but still, I think to hold that Cummings Properties or any landlord can just say that we're estimating that the worst case scenario for us is going to be that we can't relet the place, incentivizes landlords to do just that in every single time. And almost every single time, the landlord is the one with the...
Counsel, aren't you really arguing that you could calculate maybe I'm phrasing it wrong, but you could calculate liquidated damages that way, but you just can't also collect rent from a new tenant, right? Isn't that what you're really saying?
I
So
think
that
that's probably
we don't
the
need to worry too much about how to calculate them. We know we've got them here, and we know he also collected from another tenant, or they also connected from another tenant. So how do we get around our case law and join the other states in the country that don't do it this way?
Well, I think if the court were to find that the damages calculation was enforceable and as is, I think that the court could also find that it would be the landlord to decide whether to enforce that liquidated damages clause or to seek to mitigate its damages and not seek to enforce the liquidated damages clause. And I think that really is the overarching theme. I did, again, press the sophisticated party a little bit, and I think just to remind the court...
By the way, did any other states say that this kind of contract is not liquidated damages? I understand that it's a boondoggle for the landlord, but have any of them said that that's not permissible as liquidated damages? Any case say that?
I believe there are some cases cited by the appeals court.
I thought they looked at accelerated damages. They seem to have confused accelerated damages with liquidated damages. Am I misreading the cases they cite?
You know what? I don't want to misinterpret their sites either. My memory was that they did give some examples, but other than what they had cited, I don't know.
But again, is there a case that says when a landlord, this is kind of a straightforward proposition, and when a landlord includes in a liquidated damages provision, basically getting the rest of the rent, and there's the possibility that, of course, they're going to go out. We can't prevent them from renting their property after you left. So are there cases that say that's illegal besides the appeals court in the country?
I'm not sure what the other states say. I don't know the answer to that. But
because I read through the Reba brief, which is, again, it's a very sophisticated amicus, but they're talking about how bad it is, but I don't think, are they citing cases where they say that that's not allowed? I just don't see that, but,
I don't believe that they do.
yeah, that's a problem, isn't it? Because,
Well, I don't think it is. I mean, going back to the earlier question about trying to change the case law from this court for national communications, I would suggest this is a different determination. And although there was a footnote that acknowledged reletting, the case wasn't on point. And I'm not asking the court to change its jurisprudence because we're in a different footing. All right.
Okay, thank you very much.
Thank you very much.
Attorney Mingola.
Good morning, Chief Justice Budd. May it please the court. My name is Joseph Mingola on behalf of the plaintiff and appellee Cummings Properties, LLC. Each of this case that's presently before the court and of the national communications case involved a situation where the party that bears a burden of challenging the enforceability of the provision offered no first-look evidence, literally none, in an effort to carry that burden. Rather, in each case, all that they did was point to the fact that after the breach, the premises had somehow been released. However, in national communications, this court vacated the award of actual damages, which again included an offset for a subsequent tenant reletting, and reinstated the award of liquidated damages. In the case currently before the court, the appeals court vacated the award of liquidated damages and remanded for a determination of actual damages. And respectfully, the appeals court's opinion can't be squared with this court's jurisprudence governing the interpretation, the enforceability of liquidated damages provisions. It upsets the very peace of mind and certainty of result that such provisions are supposed to foster.
But it should at least have the requirement that you're dealing with a sophisticated tenant.
Absolutely. And it's interesting in this case because the concept of sophistication is one that was addressed at length at trial and in front of the appeals court. And there are no Massachusetts appellate cases that even indicate that sophistication is a prerequisite for a liquidated damages provision to be upheld, let alone whether it's an issue, a question of fact or a question of law.
Shouldn't it be?
I think the way I looked at the case law that interpreted it, the concept of sophistication I first noticed was when looking at the national communications case, where it talked about a presumption of validity of such provisions in cases where there are sophisticated parties on both sides. You see that concept also in Judge Posner in the Seventh Circuit, the XCO case. And I thought what was most interesting was a case from Maryland that my brother cited in the appeals court. It was Willard Packaging versus Javier. And there's a footnote there where they note that the issue of sophistication really helps determine the level of scrutiny to be applied to such provisions. The court noted that in Maryland, when there's a sophisticated party on each side, then the court will not even engage in a quote-unquote reasonableness review. However, in that case, which was where the employee, who the employer acknowledged was of no particular skill, was summoned to an all-hands meeting, was told to sign this non-compete or he'd pay $50,000 or he'd be fired, the court determined he was not sophisticated. So when you have that dynamic, an unsophisticated party on one side and a sophisticated party on the other, then the court would take that next step, that reasonableness review, they called it. So it seems to really go to the issue of the degree of scrutiny to be applied to the provision, but it's still not clear. There's no appellate level authority that we saw that says sophistication is a prerequisite. Going back to an issue that was raised by my brother, and he was asked about, is what is the standard of to be applied to the issue of sophistication? Clearly, the enforceability of liquidated damages provision is a question of law. But we submit that the determination of sophistication is a subsidiary question of fact. And the authorities we cited from, again, there's nothing really in Massachusetts. What they do is they look at the totality of the circumstances of the party's education, experience, background, other factors to determine whether they should be held, they can be deemed to understand the nature and the concepts of a commercial agreement. And they deem those as issues of fact because oftentimes, in this case is a great example, there was a tremendous amount of testimony about Mr. Hines' background and his sophistication.
Why is it reasonable to allow Cummings to enforce the liquidated damages and also relet? Because now the tenant has paid for the property.
There's a distinction, a fundamental distinction between liquidated damages and these acceleration clauses that require a tenant after it breaches to continue to make monthly payments which is sort of where the appeals court was going into those cases from out of state. You had the Georgia case, but the three that really stood out to me were New York and Pennsylvania, and I forget the other one at the time. And really what those cases involve are acceleration provisions that envision an ongoing tenancy. And that's where, if there's a financial breach, I can insist that you pay me all the rent up front. The lease remains in effect. The good news is it's a form of supersecurity, and it prevents the issue of a financial breach from disrupting the tenancy down the line. If, however, subsequently noise issues or environmental concerns or some other breach occurs and I have to terminate that tenancy, that prepaid rent has to be refunded. At the end of the day, this case boils down to what some people call a worst case scenario. But this court's jurisprudence, especially in the Patriots case, where they said, look, if a breach happens early in that case, a 10-year season ticket license, 1 year into it, that may appear harsh, but that's just because the breach occurred when it did. The fact that it's a worst case scenario, or it may appear harsh, or in the Kelly v. Marks case, this court talked about how there were no actual damages, it's still up to the defendant to show that that outcome, whether it's a possible double recovery, which I respectfully suggest is a misnomer, or a worst-case scenario is sufficiently unlikely.
Why do you call it a misnomer?
Well, because the notion that there's going to be a double recovery, there are two answers to that. One is maybe more of a theoretical concern than an actual fact. In many cases, and National Communications is a great example, after this court issued its ruling, we didn't collect $1 on that judgment because the tenant wasn't in a position to pay rent. It wasn't able to pay the liquidated damages amount. But more importantly, there are other damages. If you're going to engage in an actual damages calculation, there are many factors other than simply lost rent. This court, in the National Communications case, in a footnote, noted other obligations, financial obligations, that the tenant was no longer forced to incur. Utilities, real estate taxes, insurance. Those costs were put back onto Cummings in that instance for that period of time, about a year, that the space was empty. There are other issues, macro-level issues as well. There was a mention of the anchor tenant, if you will. The premises at issue happens to be a large 4-building, multi-acre campus. One of the buildings is a Superior Court. We have, among other things, coffee shops, a restaurant. We have a court reporting service. And we have many law firms that rent war rooms there or want to set up a practice there. We'd like to be able to say we have a constable's office there to take care of any needs, last-minute things that have to be served. When that tenant disappears, it somehow affects the overall issue. And if we were going down the road of actual damages, we'd be, A, upsetting the peace of mind and certainty of result, but we'd be engaging not just the litigants, but the courts.
Well, why not impose the REBA model on the liquidated damages so it has some flexibility to include mitigation damages in there to avoid this double dipping?
I think the problem with the REBA model, when I looked at that brief, was, first of all, I was taken aback by the fact that they didn't even cite National Communications or Minahane. The only case they cited that I recall was a 1950s era Massachusetts case.
I mean, clearly we'd have to change the outcome in the Patriots case in that case, but why not that? Because we can do that. Why not that?
And with respect to what I'll call, what I believe Your Honor referred to as the model, I don't think that's an enforceable provision. It sort of at times allows for an election on the part of the landlord as to whether option A or B. There was a case in the business litigation session a few years ago. It was Judge Salinger. It was Zuckerman versus Vanu. And the court there said that you had this option provision along the lines of what REBA proposed. And they said, that's not a liquidated damages provision. A liquidated damages provision is supposed to allow the parties to write on a piece of paper on a given month, here are the damages that are due this month. Next month comes, we can tape this one to the wall. We all know what the damages are. Trying to determine actual damages, which is what the REBA model wanted, I'd have more success taping Jell-O to the wall than being able to put a piece of paper up saying, here are what the damages are under an actual damages assessment.
Do you have to go, sorry, are you done?
Yeah, thank you.
Do you have, like the Georgia Court of Appeals basically says, when you do this and you re-rent, it's a penalty. We could do that, right? I mean, it would require us to backtrack, but it would force you to come up with maybe a less punitive liquidated damage provision.
Well, two things, if I might. First of all, when you're talking about liquidated damages, you're dealing with parties and freedom of contract, and there was testimony here about how the parties were free to negotiate alternative measures of damages. Or, as Your Honor indicated, if you don't like the Cummings model and Cummings is not going to be willing to deviate from it, find another lessor. Cummings is always willing to negotiate any provision of
Right,
its
but
lease.
once
including
we
that one.
okay this provision, we're going to get a lot of these provisions, right? I mean, we may already, Reba suggests that they don't exist out there, but I suspect there are more of them out there than you. And once we issue this decision, we're going to be many more, right?
I think Your Honor is correct, but the bottom line is that the National Communications case coupled with the Minahane case the next year confirmed that these are common provisions because parties would rather avoid expansive and expensive litigation that's going to include a battle of experts over whether our efforts to relet the premises were reasonable. Why didn't you offer it for $1 a square foot is what Reba had asked about at one point. But to answer the question that you just raised about the Georgia case, I think the problem with that case is that it shifted the burden of proof, it adopted a presumption of invalidity of these provisions, and it expressed grave concern that the lessor of it was a coin-operated machine of some sort, couldn't testify at trial whether or not the machine had been, I guess, released to another organization. So I think there are many factors with respect to not just the Georgia case, but several other cases that are cited and relied upon by the appeals court, none of which are from Massachusetts, that render those cases inapposite to the case at bar. If there are no further questions, I would ask that the appeals court opinion be reversed and that the Superior Court's award of liquidated damages be reinstated. Thank you.